All right, hello and welcome, and thank you so much for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C. I want to explain today something that I explain all day long during consultations and things like that, and that is the difference between adjustment of status, consular processing, and fiancé visas. And I want to explain to you I tried to draw this out as simple as possible. I want to explain to you why I don't like the fiancé visa process. So if you're thinking of applying for a fiancé visa, you can do it. There are benefits to it. There are certain benefits to it. But I want to really talk it through. I want you to think it through. Okay? So to do that, I am going to share my screen. All right, you should be able to see this sheet. I call it adjustment of status versus consular processing versus fiancé visas. And I've just got the full process laid out here, and I'm going to go through it one process at a time. So I'm going to start with adjustment of status. For adjustment of status, the idea is if somebody entered the U.S. with a visa, they're here already, and now you're getting married, the law allows that person, as long as they were inspected and admitted, they entered lawfully, and as long as you're married in good faith, as long as they're quote-unquote admissible, they can adjust status here in the U.S. If you're a United States citizen, you can petition for your spouse that way. Okay? So that's adjustment of status. Your first step is you got to get married. If you're not married already, you got to be married to a U.S. citizen. All right? There's some ways to do it if you're married to a green card holder also, but you got to still be in visa status. Can't overstay a visa. It's easier if you're married to a U.S. citizen. Step one, get married. Step two, you file the full AOS case, full case for adjustment of status. That's the petition, that's the green card application, the I-485, the sponsorship documents on the I-864, the I-693 medical exam, all of the required forms, including for your work authorization document and your travel document if you want one on Form I-131, advanced parole. File the full AOS case. I've got videos explaining that and what is the full AOS case and what all you want to include in it. Okay? So file the full AOS case. Your third step, you'll get receipt notices. Yes, there's a couple of other steps in the meantime. You'll go do your biometrics appointment. But basically, your third big event is you will get your work permit and your travel document. If you've applied for a travel document, you'll get those documents at step 3. Step 4 is you'll be scheduled for a USCIS interview, and as long as you're still eligible and as long as your case is approvable, then typically 30 days later you'll get your green card. Right now that whole process is taking, it's taking about 24 months, about 2 years. Used to take a lot less before the pandemic. I'm filming this in April of 2022. All right, so that's the adjustment of status process. Pretty straightforward process. It's the simplest process of all of them to get a marriage-based green card. I highly recommend everybody file adjustment of status if you're eligible for it. There's all kinds of benefits of doing it as an adjustment of status case. Your attorney can go with you to the interview. You can appeal it if you're denied. You could fight your case in immigration court if it were denied for some reason. There's a lot of benefits, rights that can be granted to you if you're filing it as an adjustment of status case instead of going through the consulate. But sometimes you might not be eligible to do it through the consulate. What if you can't get that visa to enter the U.S., all right? Or what if your spouse really needs to go back to take care of their affairs, things like that? They can't stay in the U.S. right now. Okay, great. Then we can file it as a consular case for a spouse, okay? To do that, you still have to get married as your first step. Then your second step is you file what we call the I-130. And the I-130 is a petition. It just says two things. One, that you are a U.S. citizen, and two, the person you're petitioning is, in fact, your lawful and in good faith spouse. That's all the petition says. And so you send that off, you wait for the approval. All right, step 3 is you wait for the approval. That'll take 18 months, okay? After it's approved, Then your case will be transferred to a place called the National Visa Center. You'll get email notifications about that. And then you can file the DS-260, which is step number 4, and the consular documents. They ask for proof that you've never been arrested, all this other stuff. They ask for the DS-260 and the I-864 sponsorship documentation. You got to upload that into the system. That's part of that process. Then eventually, step 5, you'll get your interview, and it'll be your spouse at the U.S. consulate in their home country, overseas, going in for an interview. Okay? Then, assuming that interview goes well, they cannot have an attorney with them, all right, and they'll do their medical exam overseas also. Assuming that interview goes well, they'll get a stamp in their passport that allows them to enter the U.S. So step 6 will be they'll enter the U.S. Once they're admitted as a permanent resident, and then there's just a simple fee, the Ellis fee we call it, to pay, and then they'll be mailed their green card. Okay? That's the straightforward consular process. If somebody's currently in the U.S. and they need to do the consular process, they might need a waiver, which changes the process a little bit, depending on which waiver is required. And so that adds a couple of other steps if there's something to be waived, all right? Or, for example, if your spouse had a record with immigration, say your spouse was deported in the past, well then after this consular interview, they would need to file their waivers at that point, and then waive whatever problems they had, and then get a second interview to get their stamp of the passport to enter the U.S. So if there's complications, then you might have other steps there, okay? And then the third process, which I always advise people to stay away from whenever possible, but sometimes it is the most recommendable of the processes, but rarely, all right? I like it the least. Okay, and here's why. Okay, and this is the Fiancee Visa. All right, the Fiancee Visa, the K-1 visa. So the Fiancee Visa, the first step is you file the Fiancee Visa petition. Notice your first step is not to get married. All right, so you file the Fiancee Visa petition straight away, showing that you intend to get married, showing that you're a U.S. citizen. All right, showing that you intend to get married. You have to have met in person at some point within the last 2 years. There are some exceptions, you know, if you're waiving it because of some cultural custom or because of extreme hardship. The other thing you have to show with the Fiancee Visa petition filing is that you're legally eligible to get married. So if any marriage happened in the past, that marriage lawfully ended through death or divorce, you've also got to be of lawful age to get married, okay? Or have the legal proper consent to get married from your parents, for example, if you're underage. All right, anyway, that's step 1. Step 2 is you wait for the approval of the fiancé petition, all right? Once it's approved, it'll be sent to the National Visa Center, kind of like the consular process. That's what it is, right? You're consular processing a fiancé visa. You file DS-160, which is the process of filing a temporary visa application, and you file all of the consular documents, all right, affidavit of support and other things to go along with the fiancé visa process. Then your fiancé in their home country will go to an interview before the U.S. consulate in their home country. Assuming that process goes well, then they'll be able to enter the United States. They'll have 180 days to use that stamp in their passport to enter the United States. Once they enter, though, they have 90 days to use that visa to get married and to file your adjustment of status. All right, their adjustment of status case. So they get married within 90 days, then they file the full AOS case. So step 7, once they're here, it's this same adjustment of status process, number 2 on the adjustment of status side, that's what they're filing. You file the full adjustment of status case. Step 8 is they get their work authorization document, the EAD, employment authorization document, and their travel documents. Step 9 is they get a USCIS interview, just like this, and step 10 is they get a green card, okay? Now you'll see that the fiancé visa simply has more steps, all right? The fact that it has more steps, basically you're doing a petition and a consular interview and an adjustment of status case all in one giant process when it's a fiancé visa, versus the consular process, you just do the petition and the consular, and the adjustment of status, you just do it all together, all right? So you go from simplest, to slightly more complex, to most complex, all right, in that order. And in my opinion, that's what makes an adjustment of status process so much more recommendable for people. If you're here, if you're in love, if you're planning on getting married anyway, you know you're getting married anyway, get married, file for adjustment of status. It's often the best advice, rather than have your spouse leave the U.S., file a fiancé petition just so they can come back in like a year and a half and then get married within 90 days and then file for their adjustment of status over again, when you could have just filed for their adjustment of status when they were here, all right? And sometimes they can't get here for whatever reason, and sometimes there's a problem in their home country and you can't get married in their home country for whatever reason, so you want to get married here in the United States. And sometimes your question is, how can I get my spouse here as soon as possible? And when that's the question, it's like, okay, it's possible that the petition time on the fiancé side is quicker than the petition time for a marriage-based petition. And so it is possible that sometimes entering the U.S. at step 5 will be slightly sooner than entering the U.S. as step 6 of the consular process. And so entering the U.S., if that's the goal, getting them to the U.S. as fast as possible, sometimes that's when the fiancé visa is the wisest approach, okay? The last thing that I want to say about it is, okay, sometimes that fiancé process, when you go and you're doing consultations with other lawyers and other law firms, you want to be mindful, all right? You want to be mindful, because most of the time, if there's a lawyer that's explaining it properly, the fiancé process will cost the most, all right? It will cost the most, quite simply because there's the most legal work and legal steps involved in the process. But you want to be aware of that, because there are lawyers out there that don't explain the whole process, and when they quote a fee for the fiancé process, sometimes what they're really quoting is just the fee for the I-129F fiancé visa petition. If they're quoting $2,500 or something of that, in that realm for the fiancé visa process, typically they're just talking about the fiancé visa petition. They're not talking about for the 2 to 3 years of work that's going to come after that, all right? And so you want to go into a consultation with an immigration attorney, understanding the full process, whatever the process is. You want an attorney to explain the full process. You want to know that they know what steps you're going to have to go through, your spouse is going to have to go through, and you want to have a full understanding of really what to expect, okay? That's my purpose for today's video. Thank you so much for being here. I hope it was helpful. If it was, hey, please click the like button. I'd really appreciate it. Please subscribe to our channel here in YouTube. And if we can help you in any way, please give us a call. So thanks a lot. Thanks for being with me. I'm Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream. Thank you. Bye-bye.